Senior Staff Attorney with the Electronic Frontier Foundation, and this is my colleague Seth Schoen. He's a Senior Staff Technologist at the Electronic Frontier Foundation. How many of you all are members? Okay, that's great. For those of you who haven't heard of us, we're a nonprofit based in San Francisco, and our mission is to defend civil liberties in the digital age, basically. And what we're going to talk about today is taking electronic devices and data across the U.S. border and some of the legal implications of that, as well as technological measures that travelers can take to protect their data. So we're going to basically hit four things. I'm going to start out talking about the legal situation at the border, specifically the Fourth Amendment, and what the government can do there legally. We're going to talk about border search policies and procedures that the various agencies who have border search authority use. I'm also going to talk a little bit about how to choose a strategy for traveling internationally with digital devices, because we think this is something that's very specific to the traveler. And then Seth is going to talk about some of the technical and common sense measures that travelers can use to protect data and devices during border crossings. So this presentation comes out of a paper that Seth and I wrote last year. We spent some months working on this, and we published it in December. And there is an updated version of it available to you that we've provided the conference. And so you have the latest and the greatest version that there is. I think that we will continue to update it because the legal situation changes periodically, of course. And there are going to be new innovations, we hope, that people can use to protect data. And so, if this is an issue that you're interested in, by all means, take a look at that paper and continue to look for updates on our site. So, first and foremost, the border, I think, is a difficult place when people think about legal rights. When you are crossing the U.S. border, it's often a high-stress situation. And if a border agent takes an interest in you or the things that you're carrying, I think it can start to feel like a confrontational situation. And there are some exceptions to some of the familiar rules that people tend to think that they have when they have confrontations with law enforcement agents. For example, as we'll talk about in more detail, the traditional search and seizure rules really don't apply at the border. And for example, when you are being questioned by an attorney, you often don't have a right to have, when you're being questioned by a border agent, you don't have a right to have an attorney present. And so these are a couple of the exceptions to the traditional rules that I think people tend to think that apply when you're discussing a situation with a law enforcement agent. And for this reason, we think that it's useful to think through how you would interact with a border agent if you ever were in a confrontational situation, and think about how you would protect your data well before you ever reach the border. So first of all, we'll talk about the law. So the Fourth Amendment to the U.S. Constitution generally says that people shall be secure against unreasonable searches and seizures by the government. And what that means is that basically, if the government wants to search something that you have a reasonable expectation of privacy in, as a general matter, law enforcement agents have to get a warrant. And there are exceptions to that rule. One of the exceptions, which is what we'll talk about today, is basically at the border. Because the courts believe that searches occurring at the border have a special justification, they are just considered reasonable just by virtue of the fact that they happen at the border. And so law enforcement doesn't need a warrant. And one of the major Supreme Court cases on this is one called United States versus Flores-Montano, and it sets out the justification for this rule pretty clearly. Basically, what it says is that the government has a very strong interest in preventing the entry of unwanted persons and effects at the international border. So it has the right to make sure that people don't come into the country that it doesn't want coming into the country, and things don't come into the country that it doesn't want coming into the country. And that's the reason why the government has such strong powers at the border. There have been a number of legal challenges to this border search power in the context of laptops and other digital devices in recent years. Not surprisingly, as is the case with most, with as is the case with many constitutional rights. The Fourth Amendment power to search has developed over time, and it's only recently that the question of how this might apply in the context of computers and digital information have really come up. And organizations like EFF and the ACLU have tried to argue that there should be some limitations on border searches of electronic devices. We've tried to argue that it's really not fair to compare computers to something like a suitcase because there's so much more information there. There's a tremendous amount of data that can paint a very intimate portrait of a person's life, and it's frankly a very invasive search. I will backtrack for just a moment and say that the Flores-Montano case is one in which the Supreme Court said that if you are conducting a very invasive physical search of a person, there may be a need for particularized suspicion in that sort of a case. But when you're going through baggage or any physical object, then no suspicion is really necessary. And so we've tried to argue that this is a search of digital information is a far more invasive search that's frankly more akin to a very invasive physical search than the search of one piece of luggage or some such. But so far the courts really haven't accepted that. And so they have held that when searching digital devices at the border, the government needs no suspicion of wrongdoing whatsoever, none. So in theory, they could search everybody's computers, everybody's devices, everybody's data if they had the capacity to do so. As a legal matter, that would be all right. There was a ray of hope at one point in a case called United States versus Arnold, which was in the Ninth Circuit, and in that case, in an early holding, the court said that actually because of the amount of information on a computer, the invasiveness of a search of a laptop requires at least reasonable suspicion, but that was ultimately reversed, and the Ninth Circuit said, in fact, no suspicion is needed. One of the most tech-savvy, progressive courts in the country shot that down, unfortunately. There are some interesting current cases that are navigating their way through the court system. House versus Napolitano and Abador versus Napolitano are being litigated by the ACLU. The House case, there was actually a very interesting holding just a couple of weeks ago, and that has a local connection. That involves a computer programmer named David House, who's being represented by the ACLU. He was involved with organizing the Bradley Manning Support Network. I assume everybody here knows who Bradley Manning is? Yes, okay. So he was traveling from Mexico into the United States. He arrived at O'Hare, and he was detained, and his laptop and other devices were seized, and he was questioned at length about his association with the Bradley Manning Support Network and his sympathies for WikiLeaks and what have you. And his device was then kept by DHS for 49 days. And so he, with the assistance of the ACLU, filed suit and argued that that seizure of the devices and subsequent detention of his laptop violated the Fourth Amendment, and that the government also violated his First Amendment rights by basically targeting him on the basis of his political affiliations. And the government moved to dismiss. So this is a very early phase of the case, and basically what the government is saying is, before we even get into what the facts actually are, even if everything you say is true, you still lose, just because you lose. The law is so clear on this that there's no way you could possibly win, even if everything you say is right. And what the court has said in that case so far, in this phase, is that, the government needed no suspicion whatsoever to search his laptop. However, keeping it for 49 days is another question, and it will allow the case to go forward to see whether keeping his laptop for 49 days was reasonable under the circumstances. So that's an interesting ray of hope. The court also said that it is possible that his First Amendment rights could have been violated if he was targeted on the basis of his political affiliations, and so his First Amendment claim is going to move forward as well. So that is an interesting case to keep an eye on. I also want to flag United States versus Hofmann. That's a case in which an individual was driving from Mexico into Arizona, and his laptop was seized for further review. And the border agents didn't have the forensic capabilities to search it on the spot, and so they took it about 180 miles away and kept it for a couple of days in order to search it. And they ultimately found child pornography on it and charged him with possession of child pornography. And he moved to suppress that evidence, saying that they'd violated his Fourth Amendment rights. And district court in that case said that once the government took that laptop away from the border search exception to the Fourth Amendment no longer applied, and they needed at least reasonable suspicion to hold it, which they didn't have. The Ninth Circuit Court of Appeals reversed and said, actually, because they seized it at the border, the border search exception applied to let them do whatever they needed to do to complete that search, and they didn't need reasonable suspicion. But that was just a 3-judge panel, and the full Ninth Circuit has decided to review that case, and so we'll see what happens there. It's a very interesting question. So, to be clear, the question of whether whether border search agents can actually take your devices away and, examine the information on them somewhere else without reasonable suspicion is definitely an open question. Okay, so that's a quick overview of the law, the legal situation. Now we're going to talk about what we know about what the border search agencies actually do at the border, their actual policies and procedures for performing searches. We're going to go over a little bit of terminology first. A lot of people, when they talk about searches of devices at the border, will talk about TSA, the Transportation Security Administration, but actually this is not a border search agency. This is the agency that's really responsible for domestic security, and so these guys really don't come into play with border searches. The two agencies that do are Customs and Border Protection, or CBP, and Immigration and Customs Enforcement, or ICE. Now, CBP is the one that's primarily responsible for border inspection, and these are the guys who you hand your passport to and ask you some questions when you're crossing the border. Immigration and Customs Enforcement has more of an enforcement function, and their primary mission is to investigate immigration and customs violations. You may encounter these guys at the border, especially I think if they're investigating something a little bit more in depth or have some additional questioning. If it's a fairly routine matter, I think you're more likely to be dealing with CBP. But if you're in a situation where border agents are questioning you and want to search your devices, you could be dealing with either agency. In the House situation, he actually, I think, was not sure whether his computer might have been searched by CBP or ICE. It turned out that ICE was the one that was responsible for his computer at the end of the day. I wanted to flag you occasionally hear about INS, but that's an agency that doesn't exist anymore. It's been rolled into the Department of Homeland Security, and it's just not there. So if you ever hear people talking about INS doing inspections, you can be sure that that's probably not right. It's going to be CBP or ICE. Okay, so what can they do? So without any suspicion of wrongdoing whatsoever, they can detain you temporarily and question you. They can do this up to a few hours. They can search your possessions, and they can keep them for a period of time if it's necessary to complete the search. So at times they can keep your devices and copies of data. And I think the House case shows that how long they can do that is obviously quite up in the air. They can also refuse admission. Now, in the course of the research that we did on this, we looked at the question of whether they can refuse admission to U.S. citizens, because this is sort of the common wisdom, right? They can't refuse admission to a U.S. citizen. They can definitely refuse admission to international travelers, but not U.S. citizens. We actually found that surprisingly unclear. There is a case from the District of Puerto Rico from back in the 60s that says this, but it says it just kind of, yeah, of course, if you're an American citizen, you have a right to be in the country. And there really isn't any precedent cited for that. And then there's another case that's an appeals court case that came, I don't know, maybe 10 years later. But these are the only two cases we actually found that say this. And they don't really cite the reason why. They just kind of state it. So that's kind of an interesting thing and something to be aware of. So both CBP and ICE have these published policies that you can read if you're really interested in the question that sets forth the way that their agents are supposed to be performing these searches. So according to CBP's policy, their agents are allowed to inspect devices and data with or without individualized suspicion. They may keep devices and data for a brief, reasonable time. According to the policy, that's normally not more than 5 days, but apparently there can be exceptions. They may send a device or data to another agency to seek help if they're having trouble understanding what's going on. So if they're having technical issues, for example, they may seek forensic help from another agency, or if there's encrypted data that they can't decrypt, they may seek help from another agency. Foreign languages, right? If they find something in a foreign language and they can't understand it, they may seek translation help. There's an interesting provision in this policy that makes clear that they understand that there may be some situations where an agent encounters data that's privileged or sensitive in some way or another. And basically they're like, if you run across a situation like that, you should seek the assistance of an attorney in the agency. So it's unclear how they handle that data. It is also unclear whether they can, what happens when they send a copy of data to a cooperating agency that they're enlisting for help. Yes? Well, no, that's a great question too. What is privileged or sensitive data? The policy seems to contemplate that you could have a situation where, there's medical data that's encountered, or something that's perhaps privileged in a legal sense. But I think it's a really great question. What else might be considered confidential? It's a great question. It's a great question. It's not specifically mentioned in the policy, but yeah, it's a great question. Not that I'm aware. And one of the things that's unclear is, if they get a copy of that data, do they have to destroy it? Can they keep it? Unclear. So while the policy is helpful in some respects, it certainly doesn't answer all questions. I think there are a lot of open matters that a lot of people would love to know the answers to. So ICE has a similar policy. Again, the agents can inspect with or without individualized suspicion. That policy says they generally complete searches of detained items within 30 days, but in the House case, for example, we know he didn't get it back until they'd had it 49 days. So anecdotal evidence suggests that there are situations where it can be kept longer. They argued in that case that the reason that they had to keep it so long was because it was his device contained encrypted data, and he wouldn't help them decrypt it. So that's an interesting data point. ICE may seek technical help from other agencies, just like CBP, in situations where they need assistance. And again, this policy recognizes the possibility that there might be privileged or sensitive data, but it's unclear exactly what they do with that. So if you are crossing the border, Seth and I recommend that you think about how you might handle a situation if you are carrying data that you consider extremely sensitive and you are not really willing to let border agents see it. Some people encrypt data and they take it across the border, for example, and they say, if I'm going to be asked for a password or passphrase, I'm not going to turn it over. And this could create, some sticky situations. So we have a couple of tips for interacting with agents. Avoid drawing attention to yourself. Avoid giving border agents excuses to become curious or alarmed about you or what you might be carrying with you. Be careful, be very careful not to lie to border agents. This is extremely important, and I think we're probably going to come back to this in a little bit when we talk about encrypting data. If you lie to a border agent, that is in of itself a separate. That's a crime, and so you should never lie to a border agent. It's very important. Do not obstruct an agent's investigation, and exactly where the line is there, I think, is a little bit unclear, but we'll discuss that again in a bit. But don't thwart their effort to perform an inspection. And I think it's important to be polite to agents. I mean, if you're going to be in a confrontational situation with them, I think it's possible to help diffuse the tension a little bit by not being a total jerk about what's going on, and to just be firm and polite, but just say I am not going to cooperate with you, but I think you can do that in a nice way as opposed to a way where you really escalate things. Now, they can detain you and they can ask you questions, and I think that there are situations where people sometimes prefer not to answer questions. So it's important to realize that this can have adverse consequences. It can result in further questioning. It can result in heightened scrutiny on future border crossings. I think in the wrong situation, if you catch the wrong person on the wrong day, it's even possible that, you won't be let into the country. How many people in this room are responsible for setting policies, IT policies, for the companies they work for? One thing to think about is whether the company that you work for might have a policy to help out employees in situations like this, because we think that it's worth considering whether an employee might be able to point to an external policy to help explain why he or she is not being cooperative, rather than making it seem like it's something that is a personal preference and this person is just being very difficult. If you have a policy of saying to if your employees are able to point to a policy and say, I'm sorry, I can't decrypt this for you, it's against my company's policy, we're not allowed to do that, you'll have to take it up with our general counsel. I think that puts them in a much more comfortable situation than simply saying, I'm not going to help you out. So, this is something I think is worth thinking about as something that can help out not only your company in situations like this, but your employees as well.
Similarly, if people are attorneys or if people are computer professionals who have clients, if they perceive a duty of confidentiality to their clients, that's also something that they could raise with the border agents. They could say, well, I'm sorry, I have confidential information that doesn't belong to me, that belongs to my clients. And I have a responsibility to my clients to protect that information because it's not mine. And that's also, in a way, something that could be more comfortable than saying, I don't want to help you.
Right. Great point. Yep. Well, here's the thing. When you're having a discussion with a border agent, you're just talking to another person, right? And I think it's very difficult to know for a fact how another person is going to react to something. But, I think it helps to be able to be like, listen, I'm sorry, I can't help you out here because I have this obligation or I have this duty or there's this policy and, my hands are tied. There's nothing I can do. I can't help you. As opposed to, I'm just not going to help you out. I think that tends to, produce perhaps a more sympathetic reaction from a person rather than, a feeling that you're just being difficult. So, I don't know. I think the answer is it might help you. But, then again, if you're dealing with the wrong kind of person, maybe not. Yep. Yeah, we know some stuff about it from the ACLU. I'm going to have to go back in my slides for that because you know what? I have it in a note. So the ACLU was able to figure out through FOIA that between October 2008 and June 2010, there were a little more than 6,500 searches of electronic devices. So that's like an average of about 300 a month. So when you think about the frequency of travel, this doesn't happen all the time, certainly, but it happens periodically. And our thinking is that probably it's going to happen more as border agents' forensic capabilities just get better and faster. Mm-hmm. Mm-hmm. Absolutely. I don't know if the ACLU did, but we did a FOIA suit, we being EFF, did a FOIA suit a couple years ago with another nonprofit called the Asian Law Caucus, and we were trying to figure out whether there's any sort of a profiling element to it. And the government withheld that data. There are people who have devices searched, and they do believe there's some kind of a racial profiling element to it. And whether or not that's true, I don't. That certainly hasn't been confirmed by the data that we've seen. And the government says there isn't. There are some things actually that we're going to get to in just literally the next slide that we think do have some effect on this, and might make a person more likely to be singled out for additional scrutiny. So we call this personal considerations because as we were doing the research for this paper, we came to the conclusion that really how you handle these sorts of things and how you prepare to travel is something that's very, very specific to the person and to the traveler. And there are lots of factors that go into deciding what your strategy is when you're traveling across the border and you really want to protect data. The first thing is your citizenship, immigration, or resident status. If you have worries that getting into the country is going to be harder for you than it is for certain other people, if you create an issue at the border, you may, for example, decide you don't even want to raise the issue, and so you won't even carry a device across the border. That's a possibility. Another question is time sensitivities. Do you have a situation where you need to be in a specific place at a specific time, and being held up with additional questioning is going to cause a real problem for you? What is your tolerance for hassle from border agents? Are you a really, conflict-adverse person? Would it make you really, really uncomfortable to have a situation where you're being questioned more heavily? How important is it for you to have access to data during your trip? Do you even need to have data with you, or could you create a situation where you access it only when you reach your destination? How good is your internet access going to be during your travels? If you need to access a high volume of data, are you going to be in a place where you can do that? One thing to think about, and this gets back to your question from a moment ago, is where have you been prior to this trip? In some of the cases that we've seen, United States versus Arnold in particular, there was, I think, definitely a suggestion in that case that Mr. Arnold was interesting to border agents because he was coming from an Asian country and he was a male traveling alone. And I think that they, felt like perhaps that might be a person who might have some interesting photos or data on his laptop. So, that's certainly something to think about. And then, as with, the last thing I think is your history with law enforcement. And, if you are a person of interest to the government for one reason or another, I think Mr. House might be an example. Perhaps you might be singled out for additional scrutiny. So, those two things in particular, I would say, are definitely things that come to mind for us when people say, are there certain factors that are likely to, create more of an issue for me? Okay, so strategies for protecting data, and Seth's going to take the lead on this one.
Thanks, Marcia. So I think the range of options available to people is something that's just getting better all the time as we get more internet access in more places, faster internet connections, and more. So this is a situation where people are just getting more options over time. So here are some really basic precautions that I think are sort of common sense even apart from the border search concern. You want to have backups. You want to have the backups not be carried with you. I know an amazing number of people who've had laptops lost or stolen, and some of them didn't have backups. And it was kind of sad because we're in 2012 and people have been saying keep backups for decades, and still not everyone has a backup. So make a backup. Also, even if you plan to cooperate entirely with border search, if you're confronted with a search at the border, it's a good idea to have full disk encryption on your hard drive, because you could lose your laptop. You could leave it somewhere, it could be stolen. And so encryption is just a good common sense precaution, even if you think, well, I'm not going to refuse to turn over my passphrase. You could also consider using only network storage, which is a much more aggressive thing to do, more inconvenient certainly. So a general thing that people have been interested in with regard to protecting data against border searches is not to carry it with them physically, just not to have it. And this can be a lot of work. Go all out and not have your entire laptop operating system. You can make an image of your device before a trip and then have a whole new operating system image for travel. Feels like a lot. Some laptops, of course, have physically removable hard drives, so you could have 2 hard drives and then you can just swap them. With ThinkPads, it just sort of slides right out the side, which is kind of... So you could have a little shelf of hard drives, and it's like, this hard drive is for this trip or this project, and this hard drive is for this trip or this project. Oh, I'm going on a trip. Okay, take the travel laptop. And there's also an interesting idea about booting from external media. So one privacy activist, Schoen, talked about using an SD card as his hard drive when he traveled internationally. So he'd actually put an operating system on the SD card, take his hard drive out, and just travel with the SD card, use that during his trip. And he said he would actually then physically destroy it and throw it in the trash when his trip was over, which seems a little wasteful. But he said he got great battery life because it didn't have a spinning platter. It's like like an SSD, a little slower. Yeah, I have a slide about that actually. In fact, that's slide 3 here. So another idea is to upload data at one point and then download it at another point. Of course, there are devices like Chromebooks where some of that is built in. And so this is sort of the cloud notion. With all things cloud, there's an issue of the service provider having access to your data. And so if you're using something like Dropbox or like one of the more popular cloud services, the default case is that the service provider can read the data and they can look through it. So it's nice if you have the ability to separately encrypt things before you upload them to a third-party service provider. You choose instead to your own. Our microphone is fading in and out a little bit. And in our white paper, we mentioned that there are some third-party providers who essentially insist that you encrypt the things that you upload them, and that you use a client with built-in crypto that you have the password for. So it's something to keep in mind if you decide to rely on cloud services, the issue of service provider access to your data. And someone was just asking about the idea of sending either devices or flash drives or hard drives in the mail or FedEx or something. And this is interesting, and I actually do know someone who has resorted to this. It's interesting because the devices that you send are still subject to search at the border by customs agents when they come into the US in the mail or in the common carrier package. There's a whole interesting thread about the extent to which letters can be searched at the border. And there are some policies that searching letters at the border is more legally difficult or more procedurally difficult compared to searching packages. Letters have some degree of protection in terms of the post office's policies, even if they're coming internationally. But Marcia found that there is still the potential legally that they could be searched and that they could be examined, and that there are procedures for that too. But the advantage, of course, if you're not carrying the device, is that there isn't a person who's got you in a room asking you questions and has the device. So they can look through it, but they don't have you there to question you about it. And that can be a big deal for people.
And also, you know, there's not a situation where they're going to be questioning you and then seizing a device based on what you've said in a room where they're questioning you. So.
And the other thing is that people have a level of concern about could someone bug your device if you send it in the mail? And our view is that probably US law does not give law enforcement agencies the authority to alter or bug your equipment at the border or otherwise without a warrant to do that. Yeah. I think we don't have that.
Well, the fact of the matter is we don't know that it's ever happened, right? So, I mean, our best guess is that a judge wouldn't allow it, but we don't have a court opinion saying it's not allowed because, to the best of our knowledge, it's just never happened.
There was a great recent Supreme Court decision about high-tech tracking with GPS trackers, where the Supreme Court expressed a lot of skepticism and concern about ongoing high-tech electronic surveillance of people within the US. And so that's one reason to think that judges might be concerned about electronic bugs in people's laptops, for example. Certainly those things are available technologically. You know, there are bugs that sit between the keyboard and the computer that are inexpensive and readily available. So it's more a question of what the legal standard would be, and we don't have, as Marcia said, a court case that actually addresses that directly.
So the Patriot Act is, you know, full of things that, you know, raise a lot of concerns. But I think that to the extent that that might be an issue, it would be in a foreign intelligence investigation or a terrorism investigation. And I got to say, what we're talking about here is, you know, kind of straightforward criminal investigations. We're not talking about what the rules might be if they're, you know, really looking hard at somebody because they think this person is, you know, an agent of a foreign power or something. So that I think would be kind of a different situation.
I think I'll keep going with this. So I know many of you are security practitioners and think a lot about password strength and password policies and choosing good passwords, so I don't need to belabor this issue, but I want to flag it for people that a lot of people, even for encryption purposes, use relatively weak passwords, and that could be a problem. So for example, if you look at the entropy in these passwords, organization built a machine in 1998. I mean, if you were using single disk, but and our own nonprofit organization built a machine that would be able to brute force keys of this level of entropy as crypto keys back in 1998. So not so great, right? And in fact, human memory for random password strings is not so great, and so a lot of people have suggested that you could use an altered version of a song lyric or quotation or something that's meaningful to you, generate a full passphrase, especially for cryptographic applications. Because for cryptographic applications, you're really talking about a brute force attack where someone programs a computer to try every possibility, which is less likely for an online attack against a web service, for example. And in fact, the brute force attack for an offline attack is many orders of magnitude faster. XKCD had this great, remember the passphrase from that XKCD, where he said you've already memorized correct horse battery state? He has this great cartoon of a horse being congratulated on correctly identifying a staple in a battery. Horse battery staple. This microphone is really giving me a bit of trouble. great technique called diceware. Where you choose random words from the dictionary, and a much clearer entry that's nonetheless human. It's based on words. You can choose random words from a dictionary. Can be fun. You can get interesting things that you may be able to actually think of a mnemonic phrase for. And there's a key stretching issue or key derivation issue where a lot of crypto systems use something like PBK, where they increase the effective strength of the path by making an attempt to do work for the brute. The interesting thing is that, we've heard talks. Dmitry Sklyarov gave a talk at Black Hat Europe about passwords in mobile crypto apps. And he said they're not actually using the key stretching correctly in a lot of, like the developers have heard that they should be using a derivation function for their crypto application. So they just call it once, but you're supposed to iterate it times, but they just do one iteration because they heard that for some magic reason you're supposed to be listening. Or in that allows you to check whether the passphrase is correct, and they store that in parallel. So you can check in one operation even though there's supposed to be this slowdown. So if you don't know how your disk encryption is using key derivation, you might want to calculate your password strength as if it isn't using it. And as Dimitri's talk indicated, that might actually be a good assumption in some cases. I want to pass this back to Marcia to talk about the question which is fascinating to people about forced or compelled decryption.
So anytime we talk about passwords or passphrases, I think this raises the question, what if I'm crossing the border and they want to look at my computer and they find that there is encrypted data on there, or they find that there's something that's password protected, and they say, hey, what's your password or what's your passphrase? Do I have to give it to them? Okay, so here's the deal. In the United States, only a judge can force you to reveal information to the government. So if they ask you, can you give this to me? You can say no, and there's nothing they can do to force you to turn it over. However, keep in mind that if they perceive that you are very difficult or uncooperative or whatever, they have a lot of discretion to keep you out of the country if they want to. So, while saying to a border agent, no, I'm not going to give you my password, may not necessarily get you thrown in jail, that doesn't mean that it won't have some kind of, adverse consequence. So, when I say only a judge can force a person to reveal information to the government, I want to be clear that, basically, if you refuse to give something to the government, then, they can go to a court and basically say, hey, order this guy to do it. And you may have to do that, or there may be a situation where you have a valid constitutional right against self-incrimination that protects you from doing that. And a situation like that would apply where the government forces you to reveal something that has testimonial aspects and would be incriminating to you. Now, something has testimonial aspects if it would reveal the contents of your mind, okay? So if they're basically trying to force you to give them something that is in your mind, like, for example, a password, and it would tend to incriminate you, that is, as a result of them having that password, they may learn something that might result in them bringing some sort of charge against you. You might have a valid Fifth Amendment right against self-incrimination. Now, it's very important to remember that this is the situation in the United States, and it's not the situation in every country. And there are some countries that actually have laws that require people to turn over decryption information in certain situations. I think the UK is the most famous. I also understand anecdotally that there are countries that require you to report to the government if you are bringing encrypted information into that country, like, for example, Russia and China, although I don't know the details of those laws. So if you are carrying encrypted data internationally, you might think a bit about how to figure out what the deal is in that particular country with respect to carrying encrypted information. There are a couple of interesting cases that have come out recently on this issue of Fifth Amendment right against self-incrimination and how it applies to by the government to force people to disclose decrypted information or passwords. I see we have like 10 minutes left, and so I'm not going to get into the details of those. If you're interested in them, come see me, and I'm happy to talk all day with you about it. But I think the basic rule that emerges there is that the government cannot force you to reveal decrypted information or password if you have a valid, that the information might be incriminating, and if it's basically a phishing expedition. Now, if there's a situation where they actually already know what the information is on the computer, like they've actually seen it somehow, or they're very clear what it is already, there can be something called the foregone conclusion doctrine, which basically just says, look, they already know what it is. You're not telling them anything that they don't already know. And if you aren't telling them anything they don't already know, then the contents of your mind really aren't all that useful to them anyway. They already have it, basically. You're just turning over evidence at that point. So I think that the rule that's important to know there is if they don't already know what's on it, and they're trying to force you to reveal information to them that would let them see what's on it, then you may well have a valid right there. There are other questions about whether they might be providing you immunity, and so in a situation where they give you immunity so that they're not using the information against you, at that point it's no longer incriminating, and so that can make your valid Fifth Amendment right go away. But there are also questions about whether the immunity they're providing you is enough. So it's an interesting area of the law. If you want to hear more about the cases, come and chat with me. But I'm going to let Seth move on.
You should really take Marcia up on her offer to talk more about compelled password disclosure. She's one of the world's greatest authorities on the subject and worked directly on one of only 2 U.S. court cases to ever address this topic. Huh? I'm sorry, she worked directly on both of the U.S. court cases to ever directly address this topic. As we said, the conventional wisdom is that U.S. citizens can't be refused admission. We don't have a case that clearly proves this. We don't know of any case in which a U.S. citizen who had already arrived at the U.S. border was refused admission. So we don't have evidence specifically against the conventional wisdom that if you're a citizen, you can't be refused admission. It seems clear that if you're not a citizen, then you could be refused admission. So it's good to understand how you plan to deal if you are carrying encrypted information across the border with a potential request to decrypt it. And as we mentioned, it's possible to have a company policy, in addition to a company policy that requires employees not to reveal passwords. One thing that's been fascinating to me is the possibility that a traveler would not know the decryption passphrase at the moment that they're crossing the border. This is really interesting to me, the idea of not knowing your own passphrase while you're crossing the border. This is something that I've actually been doing myself and something that I imagine that companies could do through their IT departments, or people could do with their friends, or people can do for themselves. There are all kinds of choices about how would you eventually get the passphrase back once you're across the border. With an encrypted email, or having your friend know it, or having your IT department know it, sending yourself a letter, having it on a server that you could log into, but not having it physically in your possession or control when you're crossing, right? So this is what I did when I last was on a trip. I used Lux on Ubuntu, and Lux has this notion of key slots, which are multiple copies of the decryption key that are encrypted under separate passphrases. And you get 8 key slots by default on a Lux partition, each of which can be a separate and independent passphrase. So a cool thing is that you can generate a really strong encryption key that you don't know and that you wouldn't be able to remember. You can add that as an additional key slot, and then you can delete the original one. And then if you've sent that to yourself in some way, or given that to someone in some way, then you would be able to get it back later, but you wouldn't know it. We have 1 minute left. Okay. There's also this wonderful system which has never been released in code form called keypad, where the files on your device are individually encrypted and a server knows the keys. And the server's decision to give the keys to the client can change depending on the circumstances. So if the device is lost or stolen, then you can tell the server, stop allowing this device to get keys when it, or for this period of time, control. So for this period of time, don't allow the device to give the decryption, don't allow the server to give the decryption keys to the device. So it's like voluntarily applying DRM to yourself, where you have to keep checking in with the server to read your own files. And you do this because then you can turn off your own access, or you can turn off access or audit access if the device may be lost or stolen. And I think this is a really fascinating design, and it's something that you, again, voluntarily submit to. You ultimately control the server, or your organization ultimately controls the server. There's never been code released to implement this, so we need a production implementation that people would be able to use. And you get both this auditing feature to learn what people actually looked at or could have looked at, and this control feature. And we could conceivably do this also at the whole disk level, where when you boot up the machine, as an additional factor to decrypt the drive, it would have to check in with a server that says, as a matter of policy, whether this device is currently permitted to decrypt the drive, in addition to a passphrase that the user knows. So that would be a neat thing to do. I think we're at 0 minutes, so I'm going to say, we have this TLDR already for this section. Deleting things effectively is difficult, and forensics is very effective. When you try to delete things, it often doesn't work the way you expect. Simpson Garfinkel did a classic study on this, where he bought a lot of used hard drives, and he found that people had tried to delete data in various ways, and it didn't work, and he was able to undelete it, whether they had deleted it or formatted from their operating system. Wiping an entire drive is a good idea. Peter Gutmann made people think you had to do multiple pass, but it's now thought that single pass is probably adequate, even by Peter Gutmann. If you have an encrypted volume, but it's not full disk, there can be problems with apps writing things on the unencrypted volume, such as temp files or swap files. Mobile devices are really great for forensics and really bad for counter-forensics. And border agents might search or copy the contents of your camera. Cameras don't provide secure delete, and you can undelete deleted photos with a regular undelete program. So if you have stuff on a camera that you want to erase, you may want to use your computer to low-level overwrite the SD card rather than using the camera's own deletion. So I've just skipped through, but basically forensics is really powerful and really effective. Some of you may be forensic practitioners also, and you may know this firsthand. So all of that material is in our paper, which you have access to. And we'd love to get questions or comments by email. You should definitely take Marcia up on talking about compelled disclosure of passwords and passphrases. And we would really appreciate feedback on our presentation at this URL.
As I mentioned earlier, we're going to be updating it. If there are things we haven't thought about or you disagree with us on anything, we'd love to hear your thoughts about it. Thank you, guys.